I'd like to welcome our two speakers for this evening, both of them old friends. Uh, John McGinnis and I've known since we were both rattling around as junior lawyers in the Justice Department in the middle 1980s. So both of these, I'm sure you've seen articles by both of them because they're both really giants in the constitutional law field, especially for those of an originalist orientation. You might also see John McGinnis's work. He does a regular series of essays on an excellent, I don't know, we call it a blog, a publication, an online publication called Law and Liberty. And Mike Rappaport, in addition to his other claims to fame, is the director of the Center for Constitutional Originalism at the law school at San Diego. And they are presenting a paper that they are frequent co-authors. And they're presenting a paper that really caught my eye because it's made an original argument. I don't mean an originalist argument, an original argument, an innovative argument that I had never seen before, having to do with the connection between our current political polarization and the concentration of power in the executive branch. And I would like to just have a shout out to another guest, Michael Paulson, who is also an extremely well-known constitutional law writer. Many of you I know have read some of his magnificent work, like Is West Virginia Constitutional, which I highly recommend. And he is visiting here through Hoover for about a 3-week period. And so we have the benefit of his presence with us tonight. You might want to introduce yourself to him afterwards. So with that, Michael and John, take it away.
Well, thank you so much. I want to thanks Michael and to the Stanford Constitution Center for inviting us to talk about our new paper. So the polarization of American politics is obviously a very serious issue. And at times, really, it seems like it's the most important problem in our politics today, right? And the question naturally arises, what has caused this polarization and how can we reduce it? And while there are no doubt multiple causes for it, in this paper, John McGinnis and I argue that a significant contributor to polarization is presidential unilateralism. And we argue that polarization could be significantly reduced by moving away from presidential unilateralism to political structures that require congressional consent. So unilateralism involves a government structure where the president has the power on his own to take action, such as passing regulations, initiating military actions, or making international agreements that traditionally required the assent of Congress. Allowing the president to unilaterally take these actions contributes to polarization because it leads to more extreme actions. If these actions could have only be taken with the concurrence of Congress, then the parties would have to work out compromises, especially during the usual situation where we have mixed government, divided government. Thus, government action would be much more moderate and less threatening to people under a system where we have congressional consent required. Unilateralism, we think, also leads to polarization because it leads to more frequent changes in policy. One president adopts a policy, such as, if you fill in the blank, net neutrality, whatever it might be, which the next president then repeals, and the third president comes in and then adopts that policy again, right? So these whipsaws result in a sort of disorienting and unstable world where citizens are constantly worried about what changes the new president and the other party will institute when they gain power. Now, while scholarship has been focusing in on the issue of presidential polarization in recent years, we're really not aware of any other scholarship that identifies unilateralism as a significant cause of polarization. While everyone agrees or appears to agree that the nation is polarized, there's not full agreement on what polarization is, right? And we view it as a combination of a sharp division between the parties on policy issues and an us versus them mentality between the parties. Right? So first, that sharp division means that elections take on enormous importance because the loser will really lose big, especially in a world of unilateralism. When one loses the presidency, one does not merely lose the ability to control enforcement of the laws and diplomacy with foreign nations. Instead, one loses the power as to the content of large swaths of regulatory law, from environmental to civil rights to consumer protection law. One also loses the power to decide whether to enter into international agreements, such as the Paris Climate Change Accords. Not to mention the power to decide whether to attack foreign countries, such as Libya or Panama. Right? Now, this sharp division and the rational fear of losing leads people to this sort of us versus them mentality, with people viewing the other party not merely as opponents, but as a threat to the country who should be and need to be demonized. Okay, so one of the principal ways that unilateralism occurs is through congressional delegation of regulatory authority to the president's agencies. Under existing law, Congress authorizes agencies to enact regulations based on their views of good policy, often constrained only by vague standards, such as what the public interest requires or what would promote public welfare. Now, this delegation leads to enormous polarization. Regulations are more likely to be extreme if they're enacted through delegations than if they're enacted through Congress. If they're enacted by the president and the president's agencies, then they'll reflect the president's policies. Presidents tend to occupy the median of their party, the center of their party. Thus, regulations from the president tend to be relatively extreme. By contrast, if the regulation has to be enacted by Congress and the president together, it's going to be much more likely to be moderate. If there's divided government, which holds about 3/4 of the time, then there will certainly need to be compromise in order to enact a regulation. And that's going to bring the regulation closer to the median voter of the country rather than the median voter of one of the parties. But even if there is not divided government, the regulation is still likely to be more moderate due to factors such as the filibuster and the need for the majority to protect its most moderate members who are from swing states. In a world where Congress was needed to enact regulations, polarization would significantly decrease. The parties would need to compromise in order to get legislation passed. Thus, the people of each party would not have to fear as much the election of a president from the other party, since its consequences would just not be so significant. Since they would not have to fear the other side so much, they develop much less of an us versus them mentality towards the other side. But it's not just the absence of negative feelings that'll change in that congressional consent world. In order to reach compromises, the parties will have to develop ties and to focus in on what they have in common. This promotes good feelings towards the other party. The old Joe Biden used to do that. The new Joe Biden doesn't. For compromise to occur, we need the old Joe Biden back again. Well, if delegations are a problem, then what can be done to cut back on them? Well, the most obvious solution to the problem would be for the Supreme Court to hold that delegations of policymaking discretion to the executive are unconstitutional. A strong decision cutting back on delegations would obviously have a dramatic effect. And for the first time since the New Deal, it looks like there may be a majority of the Supreme Court willing to interpret the Constitution to constrain delegation. Already, the Supreme Court has cut back on delegation through statutory interpretation mechanisms, such as the major questions doctrine, which holds that Congress must speak clearly when authorizing an agency to exercise powers of vast economic and political significance. But there are other possibilities. One possibility is for Congress to pass a law such as the proposed REINS Act, which would allow agencies to draft regulations, but would not permit them to be promulgated without Congress approving them. If this procedure was applied only to major regulations, and if it significantly limited congressional debate on those regulations, it could be feasibly applied to the most important regulations that agencies adopt each year. The policymaking discretion of agencies could also be reduced if Chevron and our deference were either eliminated or cut back. Under Chevron deference, courts defer to agency interpretation of statutes that the agencies administer. This deference means that the agencies have more power to determine the meaning of the statutes that they enforce, and therefore they have more authority to change the content of the law based on their policy views. By eliminating Chevron deference, agency power to change the laws to reflect the president's policy views would be greatly reduced. A similar result applies under our deference, which involves courts deferring to agency interpretation of the regulations that they've enacted, not the statutes, but the regulations. Now, while our deference was recently cut back by the Kaiser decision, eliminating it entirely would further reduce agency power to change the content of these regulations to reflect the president's policy views. We cut back on that. If both types of deference were reduced, agencies would have less discretion as to the meaning of the laws and therefore less room to decide what policies to pursue. John?
Well, so Mike talked mostly about the domestic side. I'm going to talk about the foreign side and then also deal with, I think, the principal objection to our proposals. Similar arguments, I think, can be made about presidential unilateralism in military and foreign affairs. In these areas, the president has usurped certain powers from Congress that the Congress had in the Constitution. He's been delegated other powers by Congress. And the result, once again, is polarization. Presidents also take more extreme actions than they could if they were required to get secure congressional approval for their actions in foreign affairs. As a result, the people fear the other side, viewing them as threats to the country. The original meaning of the Constitution requires congressional authorization to engage in offensive military actions. That requirement of congressional authorization means that a serious matter of starting a war needs to have some consensus support. This congressional authorization requirement means that presidents may either be denied authority for certain controversial military matters or required to engage in more limited military activities or activities under certain conditions. By contrast, if the president can act unilaterally, military action can divide the country, with political opponents seeking to end the action and thereby making it harder for the nation to succeed. We've seen unilateral wars in Panama, and this is bipartisan. Unilateral wars in Panama by George H.W. Bush, and in Haiti, Bosnia, and Kosovo by Bill Clinton, in Libya by Barack Obama, some of which proved quite divisive. As one political scientist noted about the justifications for these interventions, precedent built on precedent, and as that happened, executives became increasingly audacious in their claims for unilateral presidential power. Even when the president seeks authority, he does so against the backdrop that he might do it unilaterally anyway. That's what George W. Bush said about the action in Iraq, and that distorts the debate about whether to go to war, even in Congress. So the Constitution's original meaning also places strict limits on the president's ability to enter into international agreements. The Constitution authorizes treaties to be made only with the consent of 2/3 of the Senate. While the Constitution does allow some executive agreements to be made without Congress's approval, they're quite limited and don't extend to agreements that have are the supreme law of the land. But in modern times, congressional executive agreements have been used. Those are agreements where both the Congress and the president agrees, really kind of legislation about international agreements. But such agreements, whatever their constitutionality, at least have the virtue of getting congressional support. But in modern times, presidents have asserted broad authority to enter into purely executive agreements without Congress's consent, either through treaties or through a congressional executive agreement. Presidents use a variety of justifications for doing this. In recent years, the justifications have become even more aggressive. For instance, allowing agreements when they accord just simply with the policies set by Congress in statutes, which you understand is a vast delegation of power to the president, a claimed delegation. Even those, and also with statutes that neither expressly nor implicitly authorize those executive agreements. And so what are some examples of this? Well, one example was an argument made by Harold Koh of Yale Law School when he was Obama's legal advisor, and on behalf of the Anti-Counterfeiting Trade Executive Agreement. And he argued that the executive could have such an agreement simply because that was inferable from policies that Congress wanted. Congress was against counterfeiting, therefore the president could enter into international agreements. Another potentially problematic agreement of greater importance is the Paris Climate Accord, because it purports to commit the president of forever, at least for the duration of that accord, to negotiate levels to reduce carbon emissions without going through Congress, without getting a treaty. Once again, these executive agreements have potential to create polarization, because these agreements are far more likely to be extreme in the sense of not endorsed by the median voter, than agreements that must secure the support of Congress. And this unilateralism in military and foreign affairs also could be addressed by congressional action, just as some of the domestic unilateralism can be. Unilateralism in military action could be constrained by a stricter and reformed War Powers Act that was both clearer and allowed unilateral military action for a much shorter period than 60 days, because presidents within 60 days can create a lot of facts on the ground that make it very hard for Congress to act. And unilateral international agreements could also be constrained by framework legislation that denies domestic effect to only but a limited kind of executive agreements. So let me consider one, I think, and the most significant objection to our argument. Our argument assumes that parties can cooperate and compromise in order to pass legislation. But it may be objected this isn't true, because the parties simply aren't willing to compromise. Instead, the members of Congress opposed to the president's party won't be willing to compromise with the president, because they prefer to deny the president a victory that would enhance his chances of re-election. For the same reason, the president will veto initiatives from Congress that would give the other party a victory. Thus, parties would prefer to deny victories to each other than to compromise and pass legislation. I think this objection is misplaced, because it's based on a fundamental methodological error. We assume that's how parties behave because they're behaving under unilateralism. We shouldn't carry over that assumption when how they would behave under more consensus structures, because the parties will have different incentives under this regime than they did under the unilateral regime. At the president has widespread authority to enact the regulation he favors. Thus, the president has no incentives to compromise with Congress. And Congress can't secure any improvement really by compromising with the president. The best that Congress can do is hope to secure the presidency in the next election, and so act to deny the president a victory. But things will be different in a world where the president cannot adopt regulations on his own. In that world, the president of the governing party couldn't get much enacted without compromise. If they refused to compromise, both special interest groups and the general public would become frustrated and would put pressure on the party that would not compromise. That would change their behavior. Let me, in conclusion, talk about how our argument fits into how politics might change and other concerns about a too powerful presidency. So in the 1960s and early 1970s, there became a concern about the imperial presidency. There's a famous book by Arthur Schlesinger called The Imperial Presidency. But that largely focused simply on the president's powers in foreign affairs and was really concerned about that it created excessive secrecy in government and led to, frankly, bad interventions because the president didn't get good advice. Our concern is more general, and it goes to the nature of our politics itself. So in conclusion, let me talk a bit about more generally about how our politics might change in a world where the president didn't have unilateral powers. These structures, like delegation and unilateralism in foreign affairs, they encourage extreme outcomes and political polarization, and that leads to an angry and divisive politics. Because unilateralism allows the president to impose policies that don't have support of moderates. Extreme voices gain power within the parties as they influence the party to pursue these extreme outcomes. Masters of sound bites that reinforce party prejudices and party discipline, like Alexandria Ocasio-Cortez of the Democrats and Jim Jordan of the Republicans, they become important spokespeople, even if they've never proven themselves at the business of enacting bills that can gain any consensus support. Then these effects resonate outside the halls of Congress. In a world where those at the extreme can get what they want without compromise, there's less reason to listen to citizens in the vast middle of the political spectrum. Political discourse then becomes more strident, and the resulting angry cacophony creates an atmosphere conducive to more extremism and simply dismissal of reasonable objections to one party's policy or the other. But in a world where greater consensus is needed to enact regulation, to pursue military and foreign objectives, we would have a different and more productive kind of politics. Different kinds of politicians come to the fore in that politics, deal makers rather than ideologues. The media would pay more attention to people like Senator Chris Coons of the Democrats, Richard Shelby of the Republicans, because they're great deal makers and congressional consensus would be required to enact policy. With the return to a politics in which Congress enacts more law, the president then becomes less important. This will help smooth, I think, also our turbulent politics by decreasing the sycophancy that comes from presidential supporters investing their hopes in a single person and the contempt that comes from presidential opponents concentrating their fears in a single person. A political structure that requires wider agreement necessarily leads to a legislative agenda that appeals to a broader range of citizens. And that search for an agenda encourages citizens and politicians to think about something that I think is most important in a democracy, to ponder the aspirations and the needs they have in common, and listen to one another with respect to secure the support needed to get things done. The result would be compromises that would have wider support. Such a political process would unite rather than divide the citizenry, because in a world with consensus requirements, citizens are more likely to identify with the polity as a whole rather than see themselves, as I think they do today, as an embattled minority waiting for its turn to rule. Indeed, a consensus politics ultimately, and this is the greatest hope we have, improves citizens' views of one another. With less delegation and unilateral action and more compromise, we'd less often see one another as targets or as threats, and more as partners in a common civic enterprise of democracy. A political structure that rewards extremes produces demonization, but consensus structures can bring once again forth the better angels of our nature.
Yes. Yes. We'd love more questions from our online audience, but in the meantime, since you're all seated, I'm happy to bring the mic around. Anybody want to kick it off with a question? Okay, great. Please speak into the mic so that everybody online can hear you.
Hi, thank you so much for your talk. So I'm also very concerned about the concentration of presidential power leading to more polarization. But I'm also concerned that if we impose something like a non-delegation doctrine, this gives Congress more incentive and pressure to have to pass things quickly on the party line to adapt to changing circumstances if the agencies cannot. Seems to me that if that happens, it is inevitable that things like the filibuster will be eliminated, since there needs to be updates to the law, and that can't be done through agencies. It seems to me the reason the filibuster is sustained in the status quo is because Congress has naturally relied on executive action and judicial decision to move things forward, and there's no incentive to break that norm. So right now, I'm wondering if you could address the concern about whether imposing non-delegation would actually pressure Congress to act more quickly and perhaps break norms to get things done because they can't do it elsewhere.
Well, that's a very interesting question. So there's a couple of different aspects to it. So first, if we had a world without the filibuster, for a second, you might say, oh, well, one of the checks we have on enactments would be eliminated, and that's true, but I'm not sure we'd be in a worse world, because right now we've got presidents who just do this on their own. They don't even have to pass Congress. So even if there was an elimination of the filibuster, I'm not sure. I mean, I'm confident we'd still be better off if Congress had to enact it. Most of the time, there's divided government. There's lots of other, some of the things we mentioned in the talk, reasons why there would still be more moderation. I'm not actually sure that there would be an elimination of the filibuster. It seems to me that we might see, I mean, if the only way to get things passed was through Congress, we might see sort of changes in the filibuster. There are a number of things you could do that would either reduce the requirement of how many people are required to end the filibuster, or you could have a sort of delaying filibuster that would, can't pick this up, if it gets voted down, you have to wait 3 months, or so there's things that could be still adopted. It would be a reduction in the filibuster, but overall, to my mind, because of the fact that we have these moderating structures by the mere requirement of passing things in Congress, we would have far less extremism in a world without the filibuster and no delegation.
I just had one point to that, which is to note that the REINS Act actually eliminates the filibuster. So it says that if the agencies have proposed a regulation, the Senate can filibuster. You have an up-down vote. And I think that really demonstrates Professor Rappaport's point that still, I think, would get us to a much more consensus structure, even without the filibuster. So the filibuster really doesn't much constrain things at the moment once you put things in the administrative context. Once we change that world, we may want to think of modifying the filibuster to get the appropriate requirement of consensus, because that there obviously is at some point you can require too much consensus and you do get gridlock. And so the question is to get to that sweet spot, as it were. And the REINS Act, I think, is quite conscious of that by eliminating the filibuster once we have a structure where the Congress actually has to pass on a major regulation.
Question. Oh, sorry, guys. I'm going to give voice to a question posed online, asking about how your method of pushing legislation through Congress and not policy making through Congress and not through the executive branch would solve the climate crisis.
Well, I'm not sure it would solve the climate crisis. I think it would be good, but but what it would do, it would be to require that there be consensus on these matters. Right now there is it's a climate change issues are another area where the public fights about these matters. And the concern is that one party gets in and it becomes a member of the Paris Accords, and then the next party comes in and withdraws, and back and forth we go. And that's not good. You know, if climate change issues are of concern, you're going back and forth is not a great way of addressing them. So the idea would be that you get compromise on these matters, and it's something that the country can live with and support. Exactly what that looks like in the context of climate change or in any other area is another.
I get at one point, which I very much agree with Professor Rapport's answer. Let me add one point that I think in general, having more stable laws, and this goes back to James Madison and the Federalists talked about the importance of having a constitutional structure that led to stable laws, is good for economic growth. It's because I think businesses can deal with a lot of different kinds of regulations. They can internalize these costs. What they can't do is deal with regulations that are always changing, that flip-flop and that move. And so this happens even outside the climate area. You might wonder, what does this have to do with climate change? Well, the only way I think we're going to succeed with the problems of climate is to continue with economic growth so that both people are willing to pay the costs to address climate change and that we have additional money to address climate change. And so one shouldn't just think of addressing climate change as simply about regulations that focus on climate change, but the entire government structure to be a structure that is conducive to economic growth, so we can use some of the additional monies that we get there, both to address climate change and to keep people relatively happy while we're doing that, because we're not going to succeed in addressing climate change if people are feeling pinched in their daily lives.
Happy to take a question in person. I'll go to the front, and then I see two more hands in the back.
Thank you very much, professors. I really enjoyed the article. I noticed that you cited democracy and distrust, which I thought was very interesting because Dean Eli notably called for the courts to intervene in cases where like deliberation may fail us, where Congress seems institutionally precluded from operating to the best interests of the people. Election law is an example that I'm thinking of analogously here. Do you think polarization is one such problem that deliberation cannot solve? And if so, why allocate power to the deliberative branch as a remedy?
Well, I think that essentially is, maybe I'm misunderstanding the question, but I think our argument is precisely that we think that polarization is more likely to be solved within Congress because the requirement of consensus is going to demand that people make agreements, because if people make no agreements, people are going to complain they're do nothing Congress. And so the difficulty, and I think Ely's argument was, as I remember it, that the delegation was precisely problematic because it allowed Congress to escape deliberation. So I think he would have turned it around and said this was a deliberation forcing mechanism to not have delegation, which is very consonant with our perspective.
Yeah, one way to understand sort of the movement from consensus structures into presidential unilateralism is to think of it as, you know, in Elian terms, you know, a failure of democracy. And so what the courts ought to be doing, I mean, I'm not sure I would quite put it this way, but what the courts ought to be doing is preventing that failure of democracy, not by adopting the policies on their own, but ensuring that Congress and the president have to adopt those policies together.
All right, let's take another question in person. I'm going to reach over you.
Hi, thank you so much for this talk and for your paper. I've, based on my understanding in some proportional election systems and parliamentary systems, and I'm thinking of a lot of Western European countries, frankly, but you see systems where the incentives are kind of set up for that embattled minority that then gains a majority and runs roughshod, let's say, over the other party. And that goes, Professor McGinnis, to your idea of the stable regulations. I think in some of those countries, you actually don't see as stable a regulatory regime. Do those countries experience the same amount of polarization that we do? And are they doing okay?
Well, that's a great question, which would require a greater dive in the comparative politics than this paper does. And so I think it'd be a good test of our paper. Let me slightly contrast two kinds of systems. One is a parliamentary first past the post system. There, I do think you'd have some of the same problems. So that you might worry about, for instance, Britain. You wouldn't expect that system to do well. I think that's not like in a system like Germany. And let me just talk about it, about the last election. I mean, we have a structure in which we still have one of the same parties in government, the SPD, and then they've had to govern with a party that's generally thought to be more to the right of them and more to the left of them. So I'd be thinking very surprising if that does not result in a more consensus politics. So once you get to a proportional representation politics, you're going to get all sorts of interests. And so I think you're going to see more stable. Indeed, I think the first idea, again, I'm just giving the one example from Germany, was that really things weren't going to change a lot. Indeed, the head of the SPD ran really on the idea that he was going to be like Merkel, and the partner, and the agreement was going to be a little greener maybe than Merkel, because the Greens were involved, but there weren't going to be these great upheavals. So I don't think we observed the kind of radical changes in regulatory policy in Germany that we would in the United States. And I think that's in general what you would see, because almost always to make a coalition in a European context, you cannot make a coalition just from the extreme. You need some moderate policies, or sometimes you need a kind of cross ideological consensus, either through the SPD and the SCDU coming together, or through these what's called the Jamaica coalition, which combines the Greens, who are thought to be on the left, and the Free Democrats on the right. So it would surprise me, thinking from first principles, that would be the case. It would strike me that a proportional representation politics is going to lead to more stable and less extreme politics, and in that sense mimic the kind of politics we would like to see here.
The only thing that I agree with all that, and the only thing I would add to that is it just shows you, when you start to look at different countries' political systems, just how important these institutional structures are for these types of issues. So to a certain extent, a first past the post system almost is generating a kind of minority type rule to some extent. Whereas, if you look at France, where they've got this runoff system, that ensures that you're getting a more moderate. You might come in second in the first round, but you might then prevail because people support you in the second round. So and that's going to lead to more moderate results. So depending on how these institutional structures are set up, even in these completely different systems than us, you're going to get more or less consensus and polarization.
Okay, I'm going to go to one question online, and then I will go to the audience, and I will go to you first when we go back. I know you have your hand up. Someone asks if Congress could limit unilateralism in the executive branch simply by reducing the size of executive branch agencies. Would that be a sufficient fix to the problem that you point out?
No.
And if not, why?
It wouldn't be because the difficulty is not simply the size. In fact, it's not principally the size. It's the power of the president to set the policy at a relatively extreme temperature, as it were. And so simply, there may be other reasons. I don't think we're arguing one way or the other about whether the size of government is correct. Maybe you could reduce the size of the number of bureaucrats without reducing the excellence, as it were, of the output. But simply reducing the size would not, I think, achieve the problem is it's not size, but it's the discretion that is lodged in the executive branch. And size is, I think, is really an orthogonal problem to that.
And to a certain extent, the size of the executive branch is one of the issues we were divided about. So some people would be happy with a smaller size one. So even if it did give you a benefit in terms of consensus of less polarization, as to the actual policies, because they would be less important since there's a smaller size, people would be then upset about the fact that you have a smaller size.
Thank you guys for coming. My question was, you certainly make a very compelling case for the policy considerations for doing this, but one of the things you mentioned was the Supreme Court could be an agent in affecting this change. So what are the kind of legal constitutional considerations for, how much power Congress can delegate? And if this is a matter the court got involved with, what would the agencies look like in terms of kind of, what's the maximum the court could restrict Congress, or if that was even something they could do?
Well, I mean, we make the claim that, this is traditionally Congress's consent was required for all these things. If you go to the 19th century, we had much weaker presidents, we had far less delegation, so on and so forth. And so we actually think there's just sort of constitutionally, to put our other hat on as sort of originalists, that if one followed the original meaning, that would lead to very much the same place. Some of the proposals we have are, I think, totally in accord with the original meaning. Some of them are a bit more sort of compromisey a little bit, but in general, if the court were to be enforcing the original meaning, that would move significantly in the direction towards the type of consensus.
So one thing I would say is some of our proposals really don't require revisiting of the Constitution, but revisiting what the court has done. I mean, Chevron, I think it's fair to say, is a court-made doctrine that may well be, as Professor Rappaport has argued, is contrary to the APA in itself, and so we could get rid of that. Ours is also a court-made doctrine, and those, just simply doing those things, would reduce discretion in the agency. So there are some sub-constitutional matters that the court could deal with, so not changing any constitutional precedent. Moreover, there are a variety of kind of constitutional avoidance type doctrines, like requiring Congress at least to speak clearly, the major questions doctrine. So the whole variety of things that can be done. I think we do have our general views about what should be done as originalists, but I don't think you have to be an originalist to accept this view, to accept that things could be done. There's a lot of room doctrinally, even if you're not an originalist. So I'd like to think some of this could be made to a justice. Of course, now he's retiring, Justice Breyer on the court is very pragmatic. This should be a consideration for a pragmatic justice. Maybe if Justice Kagan takes up his pragmatic mantle, these are considerations that could come into him. So I do that's only stress. I mean, was an originalist, this would be a very straightforward way to go. But I think this is a consequentialist argument as well, and so it should be open to non-originalists to take up this ball.
And some of the things that we propose, we just are either sort of more moderate proposals than the original meaning would be, or even so for example, the idea that instead of having executive agreements, we generally think that you need treaties, but and we're skeptical about the constitutionality of congressional executive agreements. But still, congressional executive agreements would have more consensus than these unilateral executive agreements would. And John and I have a disagreement a little bit on the major questions doctrine. I'm a little bit skeptical about what the court's doing there, its legitimacy, but clearly it moves in the direction of less delegation. So it's not this one-to-one movement towards the original.
Happy to take another question in here. Okay, I'll come back here. But before we keep going, the audience online asked if you guys could lean a little bit more closely to the microphones. I think they are having a little bit of trouble hearing you. Thank you so much.
The proposals you've discussed seem to focus on how the president governs once elected, and I'm wondering if you've given thought to how presidential polarization can be decreased through changing how the president is elected, even working within the electoral college to maybe dilute party power, or prevent extreme positions that focus on specific states, such as ranked choice voting or other proposals like splitting up a state's electors.
We haven't really thought, too much about that. I guess I would say that it doesn't really speak so much to the presidential election process, but you do sort of raise sort of these procedures and things, and we do think that so it's not really an answer to your question, but a sort of related point, because we haven't, at least I haven't thought that much about that aspect of it, but there are certain sort of institutional mechanisms that operate today that I think would be different in a world where you had those more consensus structures. So we've got a rule that's sometimes followed where the Hastert rule, where the House of Representatives will not bring up a bill for a vote unless it has the support of a majority of the governing party. So we think something like that, if you're in a world where you have to compromise, that's going to go away. So in other words, if we're in that consensus world, structures will look different. I had another one in mind, but it escaped me.
So let me just, and again, let me emphasize, I think even who the person would be president, even the structure, the party structures for the primary might become different. It's up to some degree to the parties, how they structure their primaries. If in a world where they think they are going to need a president who's a deal maker, that they're may do different things. For instance, they may have more super delegates at the convention to understand who's a deal maker, and even the public will reset its expectations rather than having someone who's just like a tribune who may have done very little. We all have presidents in mind who are elected like that. We may actually have someone who's been tested through deals, because we understand that if that's the person, unless that kind of person is going to be elected, it's not going to be very good for our party. So I do think, just emphasizing what Professor Ravort suggested, that this really will have feedback effects, and that's probably the best way of doing that, because otherwise it's not clear that in a system of presidential unilateralism, what incentives the parties have to elect different kinds of presidents. And I think there's, to some degree, some constitutional constraints on how far we can require parties to have structures to elect the kind of people we might like.
A question online, a couple of people have asked sort of what incentives exist for politicians to want to compromise, especially in a world where, according to these audience members, sound bites that are preferenced in the media and the dynamics of social media really prefer more adversarial interaction and disincentivize compromise. So why would anybody who's currently in office want to follow the approach that you're outlining here?
Well, because, sorry. No, the world will be different under these different structures. So right now, a new president comes in, and the first day there's, a dozen new executive orders, and there's all these regulatory initiatives, and people are getting things done, and it's changing the world to a direction that they want, and the interest groups that are important in the that support that party are also going to be getting some things that they want. In a world where a president couldn't do that, come in, it's like, oh, it's a new face there, but there's not that much else that can be done. In order to actually get an agenda passed, they have to make compromises. They can't vilify the other side and then expect to make deals with the other side. So the public will become very unhappy with a do nothing Congress if the president couldn't do the stuff on his own. The special interest groups would be unhappy in a world where they couldn't get things enacted. So it would be a very different world under this system. And it's absolutely right. I mean, so this is an analogy here. Imagine you've got a teenage a child, and the parents give the child a lot of money, and he's irresponsible with the money. And they go to a counselor, and the counselor says, well, what you really should do is cut the child off. And the parents say, cut the child off? He can't even live with all the money we're giving him. What's he going to do? Well, obviously going to behave differently if money is not simply just provided in that way. Suddenly the incentives change, and maybe analogizing Congress and our politicians to a spoiled teenager is not the worst analogy.
So you've been talking about presidential unilateralism, mostly vis-a-vis Congress. What about within the executive branch itself? Since Reagan and Executive Order 12291, there's been a concentration of authority within the executive branch, first kind of negatively, but now positively to the point under the last two presidents. A lot of executive orders are basically telling executive officers who under the statutes have authority to make various discretionary decisions what to do. And there was a time when that was either not done, or at least it was only done furtively. It was thought to be somewhat illegitimate. So if Congress passes a law vesting the EPA director with a certain discretion, it was the EPA director who was supposed to decide that. It wasn't supposed to be the president telling him what to do. Do you favor a return to the older system?
So you could imagine a sort of alternative world. Like one of the questions that arises is, well, we could sort of build in, and it's along the same lines that you're suggesting, we could build in kind of bipartisan structures within each agency. So just as we have independent agencies where we've got Republicans and Democrats required, wouldn't that sort of build in? And I'm not a big fan of doing that on constitutional grounds, but I suppose that might have some effects. I'm not so sure. I mean, put it this way: in our world as it exists today, I'm not sure that presidents wouldn't use alternative mechanisms. I mean, why did we get the executive orders? when we got them, starting in the 70s. I mean, in 81 we get one, but there's already precursors. You know, why is that going on? I think part of it is because the government has grown to such a large size that it needed to institutionalize the presidential control over the agencies. And my guess is that there was sort of informal control operating. I mean, you know, if Lyndon Johnson wanted something to happen in an agency, in the executive branch, I think it happened in an agency. So I'm not so sure that it's that big of a change with the executive orders. It's just a response to a bigger government that requires sort of formal mechanisms. And if you moved away from that, I think presidents would be even more careful to make sure that they got people in the agencies who were sympathetic with their policies. So that's my take. John may have a different view.
So no, I actually think there's empirical evidence on this question. It's an interesting new paper by Neil Devins and a political scientist, Lewis from Vanderbilt. They look at the independent agencies and they find there's really very little difference in the way they behave from the executive agencies in terms of the flip-flops through agencies, in terms of their politicization, in terms even of the perception of the people within these agencies. And one of the reasons for it is, I think what Mike suggests is that consistent with what Reagan not only brings in with the executive, besides the executive order, is a new perspective on presidential personnel. And so there's a lot more emphasis on getting the right president, the people who are in ideological lockstep with the president, than there once was. And so it really, and it seems that there's very little moderation that happens through the independent agency structure. So even agencies that are outside the executive order process still operate a lot like the executive agencies. And so I don't, so I don't think there'd be much difference. And then of course there are reasons for the presidential order that are independently beneficial. There are coordination reasons. A lot of issues in government, to talk about climate change, cross-agency considerations, and you really want agencies to be moving in the same direction. I can speak some from personal experience in this respect. When I was at OLC and tasked occasionally with these governmental matters, it was absolutely important to get the agencies on the same page, and executive structures that permitted presidential coordination were very valuable. So that would be a cost, I think, of getting rid of them, and I don't think we get that much benefit from polarization, at least with the empirical literature that I've looked at.
I know we're at time, but we're going to squeeze in one more question.
Mike, John, I think this is a terrific paper. And I think you actually have me convinced that presidential unilateralism contributes to polarization. But my questions are whether the Constitution actually embraces, on a number of the points where that you would discuss, presidential unilateralism. It strikes me that sometimes the Constitution supports presidential unilateralism and sometimes it doesn't. So let me just give quick questions to both of you. Mike, is there really a constitutional non-delegation doctrine? And if so, what is its precise content? I mean, I think as a matter of policy, it would be good if Congress delegated less, but I'm not sure I see a principled constitutional rule sustainable from original public meeting that limits how broadly Congress can delegate. And then John, the question I pose to you is, do you really think that the treaty-making clause power forecloses executive agreements entirely? And if so, what exactly is the source of that? You know, why doesn't the president have a general foreign affairs policy power to make executive agreements that don't have the force of law? I have like 8 other questions. I'll save them for dinner, but I'd like to hear that.
So I do believe that there is a non-delegation doctrine in the Constitution. It exactly figuring out the contours of it is a matter of debate these days. I've got a paper on SSRN that's recently published in a book, so you can take a look there to see my take on it. But I think Elin Werman's paper in Yale does a very good job of showing that there was a tremendous amount of support for some kind of non-delegation doctrine, and sort of very strongly rebuts the claim that this was just made up. But the exact contours of it is a good question and not an easy one.
And I say again, the exact contours of the president's executive power is also a good question and not an easy one. But I would say that it's quite clear that simply because the president has some foreign affairs power, it doesn't mean that he can make agreements on any subject without a treaty. Otherwise, the treaty clause would be a nullity. There are some areas, I think, this is very much historical. One of the interesting aspects of originalism, I think, is that we are understanding that what the executive powers are, both and what the legislative powers are quite nuanced and quite have to be given a kind of historical understanding. And I refer you as to what Mike Ramsey has done with respect to trying to delineate what are the authorities that the president has to make certain executive agreements in certain areas that do not actually swamp the requirements of the treaty clause.
So thank you both for that extremely interesting presentation, and thank people in the audience for your excellent questions and attention. Please join me in thanking our speakers.